Good afternoon. Okay, so this is a little delayed. I meant to do this closer in time to the two other short videos. This is about the third reminder I wanted to give about your HIPAA rights with regard to getting your medical records. Remember, we had the video on, and I'll try to link these, the video on the fact that you have a HIPAA right to access to your records, that it is, people think about the privacy. They don't realize there's a whole section in there on part of your privacy rights is also your absolute right, generally speaking, to have access to your medical records. The next video was a little more specific to your rights to have access to your mental health records. And in that, we explained that there is a little carve out that the mental health providers are allowed to use if they choose, but they don't have to. So they can fully comply with your request if they want, or they don't have to. So I guess it depends on how much they like you. But and that was about the psychotherapy notes and what a limited tiny little piece of the record that is, but they have to provide everything else, including all treatment records outside of that little psychotherapy note about some really intimate conversations you may have had. Okay, that was 1 and 2. The third one, and this is where it drives home for a lot of my clients, is your right, if you so desire, within HIPAA, to the high-tech medical records fees cap. So what this is there is, and we, I share this kind of form with everybody. It's a HIPAA release, so it follows the HIPAA rules, but under the high tech section of the HIPAA rules, if you request your records to be sent to you in a high tech fashion, meaning electronic, and the provider maintains electronic records, or portability, they have to give you the records in the digital form that you requested, the electronic form. That would be generally like, there's multiple ways, but it could be email, it could be fax to the number you give them or the email you give them. It's none of their business whether they like your email or not. The other alternative is by CD. Antiquated, half the time they don't work. I don't recommend it. The form I have shared with people that I received from HIPAA professionals was on the HIPAA professionals on this side of the fence, not on the provider side of the fence, but on the patient side of the fence. It specifically gives them 2 options they can choose from: fax or email. The email could be an actual email of the PDF, the 500 pages of records, very easy to send, or sometimes they do it by download because they keep it stored someplace, and whether, using a little password or whatever, you can go to wherever the link they say and download it, and they send you the password. So either one of those works fantastic. Again, the CDs don't tend to work. They're very unreliable. They often require a password you don't have. And it's like if you don't use the system that they make their CDs work with, you might not be able to access it anyway. And you have to have a special machine to read a CD. Most computers don't have that anymore. So if you ask for it electronically, and you could tell them which way you want it, right in your little high-tech HIPAA form, they have to send it to you still within 30 days of the regular HIPAA rules for providing access. And they can't charge you a search fee. They can't charge you per page. Think about it. A lot of places have been charging $1 a page. And if you have $700 of pages from like a hospital stay, you're going to have to come up with $700 to get them. Completely gross and horrible. But under this federal law, which preempts every state rule, unless the state, provides for a cheaper fee, so it can be more favorable, and then they have to follow their own rule, or they have to follow the basic floor of protection for the patient that's under federal, the high-tech HIPAA provisions. So again, no search fee, no per page, no mailing fee if you don't ask for a CD. So you don't have to, if you did ask for a CD, you're going to have the mailing charges, you're going to have the cost of the CD. I've seen those costs jacked up. They're not giving it to you at cost. That's not legal. But if you do by email or by fax and it's electronically sent, there's none of that. So the only basic charge generally that they can charge you is the labor charge. Now let's imagine what is the salary for a person whose job it is to send out medical records. I'm guessing it's under 50,000 a year, and I'm probably being very generous there. So that's $25 an hour if they make 50,000. And if it takes 5 minutes to shoot you an email with the link to your records, what is that now? 112 to 25, a couple bucks. So they can charge you that actual amount. If there is a provision that if they don't want to have to figure out the actual amount, they can just charge you like $6.50. If they want to charge you more than that, they have to prove that their actual labor costs, relate to that. And if that were the case, if they said, we're going to charge you $75 and that is our actual cost, I would demand to see an itemization. I want to know the employee's name, their salary. I'd want the proof, because no one's going to be paid that much to do this. So it's like a clerical job, So that's the high-tech HIPAA access. So we use all three. The right to access to your records, period. It's just a flat out right. The second one is, okay, you got that tiny little carve out for mental health providers, but otherwise the mental health providers need to know what they need to do, because a lot of them are going to be getting themselves in a bind pretty soon, I think, with HIPAA, because they've been violating people's rights, probably not even knowing that they're doing it. I don't think they mean it, but it's been rampant. And the last one is, and if you ask for it with high tech, using the high tech version of the HIPAA form, you can by and large get your records for well under $10, okay, for each request that you make. So it's huge cost savings. Before we had this, I wasn't advancing people tons of money, like my clients, to get their medical records. Now, even though it's still their responsibility, the amount, it's their out-of-pocket expenses, as is their medical bills and their dry cleaning bills and everything else. But I don't have a problem advancing it when it's $6.50 or $7 or $6.89. It just doesn't, it's seamless. It goes out, So I'll help them cover that, because sometimes they don't even have a debit card or a bank account. So we do that for people. But anyway, so that's the third one. High-tech HIPAA. It is the best thing next to sliced bread. The federal government occasionally gets it right. That's one of them. Okay. I don't even like all the rest of the HIPAA rules necessarily. I've seen it be taken the wrong way. It's hurt a lot of people. It also obviously protects people. But the high-tech HIPAA provision for access, spot on. Okay. That's the third thing. You should have no problem now getting your medical records and not having to go bankrupt to get them. Okay. Ciao for now. Bye.